Good afternoon, everyone. I am Paul Edison, Assistant Professor at Department of Corporate Secretaryship, Guru Nanak College. I am happy to give lecture on the topic classification of contract. The legal provisions governing contracts are contained in the Indian Contract Act of 1872. Introduction. The term contract is derived from Latin word contractum, which means drawn together. It is an agreement to do or not to do an act. It comes into existence from the actions of the parties. It creates legal rights and obligations. It is enforceable by law. Definition of a contract. According to section 2, subsection H, a contract is an agreement enforceable by law. It must fulfill two conditions. There must be an agreement. Such agreement must be enforceable by court of law. What is agreement? Section 2, subsection E defines agreement is a promise or set of promises forming consideration for each other. In general terms, contract equal to agreement plus enforceability by law. Agreement equal to offer plus acceptance plus consideration. What is promise? According to section 2, subsection B, a proposal when accepted becomes promise. Without consensus ad idem, there is no contract. Consensus ad idem means identity of minds or meeting of minds. The parties to an agreement must agree on the subject matter in the same sense at the same time. Without consensus ad idem, there is no contract. Classification of contract. Contract may be classified as according to enforceability, according to formation, according to performance. According to enforceability, there are 6 types of contract: valid contract, void contract, voidable contract, unlawful agreement, illegal agreement, unenforceable contract. According to formation, there are 3 types of contract: express contract, implied contract, quasi contract. According to performance, there are 4 types of contract: executed contract, executory contract, unilateral contract, bilateral contract. According to enforceability, valid contract. Valid contract is that contract which satisfies all essentials of section 10 of Indian Contract Act, like lawful offer and acceptance, free consent, consideration, capacity of parties, etc. For example, A asks B if he wants to buy his bike for rupees 10,000. B agrees to buy the bike. It is an agreement which is enforceable by law. Hence, it is a contract. Next, void contract. Section 2, subsection J. Void contract is one which was a valid contract when it was made, but subsequently it becomes void due to change of circumstances. For example, X agrees to sell his horse to Y for rupees 5,000, but the horse died in an accident. It becomes impossible to perform the contract due to destruction of the subject. Thus, a valid contract changes into void contract because of impossibility of performance. Next, voidable contract. Section 2, subsection I. An agreement which is enforceable by law at the option of one or more of the parties thereto, but not at the option of other or others, is voidable contract. A contract is a voidable contract when the concern or willingness of one party has been obtained by the other by such unfair means of coercion, undue influence, threatening, fraud, etc. For example, X promised to sell his scooter to Y for rupees 50,000. However, the concern has been procured by Y at a gunpoint. X is an agreed party and the contract is voidable at his option. Illegal agreement. An illegal agreement which is prohibited by law or against the policy of law is known as illegal agreement. For example, X agrees to kill Y if Z pays him rupees 10,000. It is an unlawful as well as a void agreement. Next, unenforceable contract. A contract which is valid in all respects, but because of non-fulfillment of some technical formality, it cannot be treated as enforceable. For example, a deficiency in stamp duty, if a person forgot to sign the agreement. Next, according to formation. Express contract. The contract is said to be an express contract when terms of contract have been agreed upon between the parties expressly, that is oral or written at the time of formation. Usually it will be in a written form. Implied contract. An implied contract is one which come into existence by the acts, the conduct of parties. For example, order placed for a cup of coffee in a restaurant. It is implied that a person who ordered coffee has to pay the bill. Quasi-contract. In a quasi-contract, there is the intention of the parties to form a contract but created by law. For example, X, a trader, leaves certain goods quasi-contract. In quasi-contract, there is no intention of parties to form a contract but created by law. For example, X, a trader, leaves certain goods at house of Y by mistake. This imposes an obligation on Y either to return the goods to X or to make the payment if he treats the goods as his own. Executed contract. A contract is said to be executed contract where both the parties or at least one party to a contract have performed their respective obligations. For example, all transactions of cash sales are executed contract. Executory contract. An executory contract is one where both the parties are yet to perform their respective obligations. Bilateral contract. A bilateral contract is one in which both the parties are required to perform their obligations at the time of formation of contract. For example, A promises to sell his car to B after 20 days and B promises to pay the price on the delivery of the car. The contract is bilateral as obligations of both the parties are outstanding at the time of formation of the contract. Unilateral contract. A contract is said to be unilateral where one party has performed his obligation and the performance of obligation is outstanding on the part of other party. For example, X buys a railway ticket for journey from Chennai to Delhi. X performed his obligation under contract by paying the fare, but the railways are yet to perform their duty, that is carrying X from Chennai to Delhi. Thank you. Let us discuss about the essentials of valid contract in the next session. Thank you.